Back to Brian Claypool, who's a criminal defense attorney and live with us from San Diego. Brian, we remember this jury instruction that said that basically if you find beyond a reasonable doubt charges with respect to Jane Doe number 2, the jurors could use that in deciding charges with respect to Jane Doe number 1. This jury instruction clearly didn't work because they were hung on the counts with respect to Jane Doe number 1. Now, as a defense attorney, you are trying to not have a retrial with Jane Doe number 1. Is there anything about that instruction, or is there anything about the argument that the prosecutor was trying to connect Jane Doe 2 and 1 that would help you in arguing, let's say, double jeopardy has already attached?
Well, I don't think you can argue double jeopardy, but I think what I would do if I'm defending Kellen Winslow II in a retrial is I would think very long and hard about having him testify, because sexual assault cases, defending somebody charged with sexual assault is much different than, for example, a murder case. Why? Because in a murder case, the victim's dead. The victim does the murder victim can't get on the stand and say, hey, he or she did it. In these sexual assault cases, we heard, you even got a 7-5 on Jane Doe 1. They all got up there and they thrashed Kellen Winslow II. And Brian Watkins made a comment in a press conference. He said, hey, there was no corroborating evidence. Well, that's right, but you do have other evidence from all Jane Doe 1 through 5. So I think they really have to think long and hard about getting Kellen Winslow II on the stand. He's going to have to refute these allegations, humanize himself, personalize himself, and that could be the minimizer and the game changer when this goes to a retrial.
Oh, absolutely. They have to do something different because we know that statistically retrials favor the prosecution, and especially with all of these splits. Now, with Jane Doe number 2, Winslow was found guilty on count 4, which is the forcible rape, but the jury was hung on the sodomy by use of force. The split was 10-2 in favor of guilt. How do we see this one playing out? If this goes to a retrial, I just can't see conceivably how the jury is going to hear about this. She's going to testify as to one count, and then the jury is going to know about the conviction of the forcible rape. It seems very convoluted. Well,
that's a great point. But before you even get to that, my appellate brain is thinking about another issue, because when I did 2 retrials for Dalia DiPolito in West Palm Beach, Florida, we had an appellate lawyer sitting in the first row of the courtroom, in the entire both trials. And what I would be thinking about right now, if I'm the defense lawyers, I know it's a long shot, but I'd file a motion before Friday arguing that there's a potential inconsistent verdict as to Jane Doe number 2. And that's a grounds for getting a conviction thrown out. And what I mean by that is, how can you have 12 jurors rule on one hand there was a forcible rape of Jane Doe number 2, but yet not have those same 12 jurors find that there was sodomy? That could arguably be an inconsistent verdict and grounds to throw out that conviction. I would raise the issue.
Okay, I love the idea. I love that we're like legal nerding out right now with the motion for the inconsistent verdict. I think that's a great idea. But don't you think the hang up is, okay, so for the forcible rape, it was the vaginal intercourse, and the sodomy by use of force was the anal intercourse, the allegations of both. And Jane Doe number 2 even said she didn't know if the sodomy was by accident. And although you don't need intent, it's just the act itself was enough. But that could be the argument against the inconsistency.
Well, look, at the end of the day, I mean, if she's saying, I mean, you could even use that in the motion. Like if Jane Doe said, well, it could have been an accident as to the anal portion of this. I mean, if I'm Carlos and Watkins, I'm going to argue that the evidence doesn't support the jury verdict as to Jane Doe number 2. That she's saying, oh, well, gee, it was an accident as to this, And remember, you had the forensic nurse too, right? She came in and said, "Hey, I can't tell there's no forensic evidence here that supports a sexual assault." She said that. So you have that combined with Jane Doe number 2 saying, "Hey, the anal portion might have been an accident." I mean, I'd file two. I'm just thinking outside the box. I'd file 2 motions if I'm the defense lawyers: an inconsistent verdict on Jane Doe number 2, and also that the evidence simply doesn't support a finding of guilt on Jane Doe number 2. And getting back to your question real quick, I think if I'm Dan Owens and I'm retrying all these cases, I eliminate the sodomy charge as to Jane Doe number 2. Why? Because you don't want to create any problems in the retrial that's going to end up in a mistrial in the second retrial. You just don't need that. You already have the conviction on the forcible rape.
Okay, Brian Claypool, can I ask you to stick around? We have more to dissect in this verdict in California versus Kellen Winslow II. Folks, stick around. Our breaking news coverage continues after this.